the next phase that we're talking about is implementation. Now that we've done the screening, now we move into implementation of the practice. And as I mentioned, I think that the best place to implement this is really in a two-phase process. The first would be early intervention. And that means that after the insurance company has done their investigation, their brief investigation, after we've screened the parties, we get the stakeholders together with a facilitator. And the purpose of that meeting is to have the injured party explain what happened, have the offender or negligent party explain what happened, offer an apology, express genuine remorse if that's there, and then the parties agree that over the next months or years they will collaborate to understand, evaluate, and ultimately repair the harms and losses that have been caused. Now, I would suggest in order to deal with the concerns of an insurance company or even the insured about, well, what happens if I admit I was wrong, I was at fault? Can't that be used against me? Well, in my way of thinking, it can be and it should be. However, there is still some concern that we don't want that to be necessarily. So if we do it under the auspices of, for instance, in Colorado and in most states I think we have, mediation or dispute resolution acts that provide confidentiality for anything that happens in a mediation or a settlement conference as part of the ultimate resolution of the claim, then what's said and done in that practice is generally confidential. So to the extent that the insurance company or somebody wants that protection, I think we can easily create that by having this a restorative mediation as part of the settlement practice. There are some laws around the state that protect malpractice in malpractice claims, that protect doctors and the participants from using statements of apology in any later civil litigation. So there are a number of states that have that, including Colorado. But I'm not sure that that's necessary. We have some protections, but if we do it within the context of a mediation or under the Dispute Resolution Act, I think we can protect that. People would say, well, why would we do that? Why would we want to have this early intervention? And I think the reason is because there's been a lot of research that has shown that if you can deal with the anger and the emotional needs and concerns of the injured party early on, they will heal better and faster and cheaper. Some of the examples of that comes from the trucking industry. A number of years ago, there was an effort to incorporate these kinds of early intervention practices in serious trucking accidents. They called it the negotiating counsel model. And there are anecdotal reports, and there's more than anecdotal reports, there's good data that shows that those companies that have implemented this kind of practice have saved millions and millions of dollars. More importantly, or as importantly, they've helped the people that have been injured as a result of a trucking accident. They've helped these people move through the system, move through their healing process in a much more humane way than the traditional adversarial process. And the reports from executives, from trucking executives and so forth, claims representatives, have been very positive, that this has been a very positive approach for some companies. Now, obviously not all companies have adopted this, but those that have, I think, have been very pleased with it. And there's no reason we can't do this in a whole variety of situations if the parties meet the screening criteria that we talked about. So one of the questions, I think, and we talk about needs of stakeholders, one of the questions might be, well, what about the lawyers? What role do the lawyers have in this? Aren't lawyers going to be making less money? Because one of the needs that, I don't think I mentioned it, but one of the clear needs of lawyers, as in most people, is they have to earn a living. And in the legal profession, those of us involved in personal injury litigation, we make our living by handling negligence claims. And so there might be a fear that for the plaintiff lawyer, maybe for the defense lawyer, that this is going to affect their well-being. I would suggest and submit that it doesn't have to in any way, shape, or form affect their well-being. And here's what I mean by that. In my practice, generally, what we do is my staff and myself, we're involved in gathering information about an injury. All kinds of information about the injury. Medical records, of course, wage records, of course, anything where we've identified that this person has been impacted, that there's been a harm. My job is to gather as much information about that harm as possible. And of course, I gather information to show what the person was like before, So I have to gather that information and now show how this particular incident or injury has affected them. The second role I have after I've gathered all of that is to evaluate that information. Most of my clients don't know how to evaluate their losses and their damages. That's my job, and I can help them do that. And in this process, lawyers would still help them do that. And then ultimately, I would help them negotiate. As a lawyer, if I were an advocate in this situation, I would help them negotiate for some reasonable or fair compensation to repair the harms and the losses. That's my job. So I'm not doing anything differently than I would do otherwise. Now, if I can't get it resolved, then I'm going to move on perhaps to litigation, unless the lawyer is part of a collaborative process, in which case he would stop after that negotiation, and then you would have the litigation counsel take over from there. And you might say, the defense lawyer might say, well, what about me? I got to bill these hours. I've got to work the discovery. Well, some discovery might take place, but more importantly, the lawyer's role from the defense perspective would be to also gather information, which they do, evaluate that information, and ultimately help to negotiate a settlement on behalf of their clients or their insurance companies. So their role doesn't significantly change. What changes is their approach to it, that they come at it with the idea that they were going to restore or repair the harms that have been caused if we can. That's our first goal. And if they come at it with that attitude, they can still do the same things they did before, but they have a different perspective, perhaps a different outcome of what they might be able to accomplish. Can I suggest that there might not be less litigation? I think there might be less litigation. I'm suggesting there would be less litigation. So I think those lawyers might need to find a way to utilize their talents in other situations that need to be litigated, because we're not going to resolve all of the litigation. But we might reduce the litigation. I would doubt very much that most people would find that offensive if we reduce the amount of litigation. I think that would be a good thing all around. So now we've had this early intervention process, and the question, okay, now what happens in between? We've had this early intervention. What happens in between is basically a monitoring and a supporting role. So all of the stakeholders agree that they will monitor the situation, they will support the injured person, and then ultimately we're going to come back when that person is able to identify all of their harms and losses, both past and future. We're going to come back and ultimately resolve the claim in a similar process of what's done now, in typically a mediation or a facilitated process, whether we call it settlement conference or mediation. We're going to go through that same process. But here's the advantage, and here's the difference. The injured party isn't angry, they're less fearful, and they're certainly much less frustrated, because they've been acknowledged, they have an understanding of what happened, they've been able to move through the process without having to deal with all of the adversarial issues that come up. And now when they get to resolve it, they're ready to resolve it and they're ready to move on. And the experience for most practitioners is that if you have an injured person who is ready to move on, who isn't holding that anger and fear and frustration, they'll settle their claim for a reasonable amount of money that is enough to compensate them to repair the harms and losses, and that's it. You won't have to be dealing with all of the other baggage that in most cases, after a year or two of litigation, there's a whole lot of baggage that both parties carry into that mediation that oftentimes impedes the progress, and it makes it more difficult to settle those cases. I've been doing mediation work now for over 30 years, and oftentimes I will talk to the parties about where are they emotionally in this situation? What are their needs emotionally? What do they need to come out of this? And very often that's the case.